Good afternoon. Thanks for joining me today. Today we're going to be talking about defending claims against people who are not our employees. Today is April 26, 2021. Thanks for joining me for our New Jersey Workers' Compensation webinar. So let's talk about what we're going to talk about today. We're going to talk about the defense of non-employment. It's pretty straightforward. I'm also going to do a quick case law update because there was some breaking case law that came out about 2 weeks ago from New Jersey Supreme Court concerning the medicinal use of marijuana in New Jersey workers' comp claims. I actually got a question while we were in the lobby saying, Greg, are you going to talk about that? And yeah, I am going to talk about that because that's interesting. Then we're going to talk about employee status and how we defend those cases. And I'm very happy to talk about any questions you have about employee status. And I've received a lot of questions over the years about Uber employees, DoorDash employees, anybody who's an employee in the gig economy and how those are treated under the workers' compensation law. And then a lot of questions about special and leased employees. So we'll talk about those. My goal here today is to answer as many questions as I can and give you as many practical takeaways and useful advice that I can. Please ask questions. It makes it so much more fun. So questions and answers really are something I look forward to. And as we have these slides change, please feel free to just type in your questions as we go. So let me just jump off. Just very recently, Supreme Court upheld a decision in New Jersey saying that yes, medicinal marijuana can be used as pain management treatment in a workers' compensation case. And the issue has always been, well, who pays for it? And the carrier, employer side, we've been saying, wait a second, we shouldn't have to pay for this. First of all, it's violative of federal law. It gets us involved in providing controlled substances to people that is still under Schedule 1, limitations, etc. New Jersey's had this very silly-hearted Compassionate Use of Medical Marijuana Act, the CUMA Act, that has been in place since 2015. Since that time, medicinal marijuana has really grown in New Jersey, and we've seen all sorts of issues arise from the dispensaries and how the doctors are licensed or trained to dispense it, et cetera. But from a workers' compensation context, initially we were disputing that the carrier would be responsible for paying for medicinal marijuana, simply saying it's a scheduled substance. We're paying with bank checks that are crossing state lines. You know, we've got all sorts of federal preclusion of this issue, so we're not touching it. And about 2.5 years ago, a workers' compensation law judge did not order the carrier to pay for medicinal marijuana directly, but simply to reimburse the claimant for medicinal marijuana that he had obtained on his own through his own means. And that decision has wended its way through the courts, and obviously it's been very closely watched by a number of carrier and employer entities, as well as the claimant attorneys. So ultimately, the courts have ruled that yes, it's okay for the employer or carrier to reimburse for the cost directly to the claimant. Again, we're still not seeing any direction that says that we are to directly pay for it. Obviously, not touching. The New Jersey courts have no ability really to resolve issues involving federal law. And again, marijuana is still a Schedule 1 substance and banned by federal law or prohibited from use. Now, my understanding of this case, again, it just was decided by the Supreme Court, is that the parties to that case have decided to take it up to the federal courts, and so they will be looking for leave or filing an appeal to the federal courts shortly. So that appears to be something that's going to go on. So there's going to probably be a little more to this saga. However, we are going to see more demands for reimbursement for medicinal marijuana in New Jersey workers' compensation cases. As the employer carrier, I'm just going to give you two thoughts. One, if you get an order stating this, you can still dispute these orders. I mean, if a claimant comes in and files a motion for med and temp seeking medicinal marijuana, and that's something you want to challenge, obviously you can still defend that motion or dispute that care is necessary and palliative. The other thought I have is this might actually be useful for some of those of my clients and some of yours who have workers' compensation cases that we're trying to resolve by way of Section 20. But we've discovered that there is a large Medicare secondary payer allocation that would need to be satisfied. So think about those old dog cases that you're trying to resolve for $150,000. Let's just throw out a random number. pursuant to Section 20, but then you've got a huge set-aside allocation because the claimant's on long-term pain meds or narcotics, et cetera. Well, if you can get them onto medicinal marijuana, which is a Schedule I substance and will not be ever paid for by Medicare under Part D, you can then exclude it from that allocation. And at that point, that should help you adjust or reduce that allocation. So just some thoughts about how we're kind of aggressively or creatively trying to utilize this in favor of the carriers or employers, looking to maybe shift some of that palliative long-term care onto medicinal marijuana. Now, the challenge, of course, from the allocation standpoint, and I just wanted to be thoughtful about this, is that medicinal marijuana is not proven to be any cheaper than the sort of medical opiates that we have been distributing. So you're not going to really be getting any cost savings here, but it might be a way to avoid a Medicare allocation. So it's a little bit of out of the box thinking. If you have any questions about medical marijuana or this quick update, type them in now, and I will certainly get to them when I get to questions at the end of this presentation, which again is totally live. All right, it wouldn't be a Greg Lois presentation if I didn't talk a little bit about our 2021 New Jersey Workers' Comp Handbook. If you haven't grabbed it yet, we've fixed it up. We fixed the website up. You can go and download any of our handbooks. We have a handbook for New Jersey workers' compensation, for New York workers' compensation. We have a specialty handbook for construction defense and one for longshore defense. You can go to our website and download them. That's loisllc.com/publications. There was an issue, I think, with the downloads not actually reaching people. That's been fixed. So if you haven't gotten your copy yet and you want it, that's where you can go, instantly download it. Our New Jersey handbook this year, there was a lot of changes into it. Obviously, the chapter on COVID-19, again, COVID-19 is presumed compensable in New Jersey. However, you can still challenge, defend, and win on disputing the causal relationship of COVID-19, and we certainly are doing that. I do talk about the October decision in which extra jurisdictional medical provider claims were all found to be lack jurisdiction in New Jersey. In my practice, we've seen literally hundreds of those cases getting dismissed. So if you have cross-jurisdictional medical provider claims, we're getting those things thrown out left and right. I talk a little bit about successive exposure claims, and certainly you can guess for 2022, I'm going to be talking about medicinal marijuana, so that'll be a new thing. I can tell you that along with my co-author for the book that I write for LexisNexis, which is the New Jersey Workers' Compensation Guide, that's the Matthew Bender imprint book. We are certainly revising it right now, our editions, to make sure it includes this latest case law on medicinal marijuana. All right, so that's what's new in Jersey. Let's dive into today's topic. And again, I'm gonna just keep encouraging you guys to ask questions. We do these webinars 4 times a month. The first Monday of the month, construction. Second Monday of the month, we only talk about risk transfer in multiple jurisdictions. Third Monday, we talk about New York, and we're in the fourth Monday of the month, so we're talking about New Jersey. And I could tell you that as we do these presentations, and we're reaching hundreds of people a month, the presentations where there's questions makes it such more fun, and it's easy to type in a question. You can just use that little pull down if you're watching me on your phone or something. They also have a little tab you can click and jump over there, and we will answer as many you can send. All right. Who is an employee? Well, it's defined in the statute. Section 36 of our statute contains all the definitions for the New Jersey Workers' Compensation Law. It's someone who provides a service for financial consideration. In general, they're going to have a pay stub. Hopefully, they'll have a W-2 if they've worked for the employer for long enough. But of course, the workers' compensation courts have held people that are cash employees who are going to be working off the books, or they were new employees. The employer didn't have a chance to report them yet to payroll, or maybe put them on the payroll. As long as the person believes that they're working under the direction and control of the employer, as long as the employer admits it, they're going to be deemed to be our employee. I just want to remind everyone that New Jersey excludes longshoremen from the act. There is an exclusive jurisdiction there. If you have a longshore claim, you cannot bring a workers' compensation claim in New Jersey. You have to bring a longshore's claim. And in my office, we defend them both ways. We see claimant attorneys who file the New Jersey workers' comp claim, don't file the longshore claim. And so we'll kind of look at like which jurisdiction would be more beneficial to us. And I also see it much more common the other way. They file a New Jersey workers' comp claim and they fail to file the longshore claim in time, and they blow the statute of limitations on that. And that has been the subject of a lot of claimant attorney malpractice over the years. So New Jersey and Longshore have exclusive jurisdictions. Either you are a Longshore or you're not. And if you're not, you're entitled to workers' comp in New Jersey as an employee. So let's be thoughtful about that. All right, let's talk about what about sole proprietors? Yep, just like every other state, they can exclude themselves from their coverage. Some sole proprietors choose to be covered by their workers' compensation. I'm the owner of this business. I choose to be covered for workers' comp. Owners can generally exclude themselves if they want to. That's up to the owner. What about illegal employees? And really, I'm talking about pre-citizens. We're talking about our undocumented. We're talking about people with actually no employment eligibility in this country. They have been deemed to be employees by case law. They are treated the same, and there is no advantage to employers who are hiring pre-citizens and hoping to get out of paying or being responsible for workers' compensation coverage for those employees. Sure, I'm sure you're not paying taxes on them and benefits, et cetera, so I'm sure you're still getting ahead, but it's not going to work in workers' comp. Minors, of course, under the age of 18 without working papers are considered a minor. They really shouldn't be working unless they have the specific working papers, and they can be receive either double workers' compensation award, or they have the right to go and file a remedy in the civil arena. So they are not bound by the exclusive bar of the Workers' Compensation Act. They can directly sue the employer if they're under the age of 18 and employed and working and injured. All right, who isn't an employee? Well, in general, your vendors, your subcontractors, your casual employees, independent contractors are not employees. But we're going to define what all these things mean as we go through this presentation quickly, just to talk about that, because that question of who's an independent contractor is a huge issue. And we know that a lot of people are classified as independent contractors maybe for tax purposes, but when it really comes down to the nitty-gritty of workers' compensation law, they're not going to be found to be independent contractors. They're going to be found to be your employees. So we'll talk about the tests. New Jersey also recognizes dual employment, and that really takes place in the context of lent employees. So we have an employee leasing company, or one company is lending employees to another company, and we're really looking at here specifically, think about your PEO or your staffing agency. They're going to have under that same dual employment. However, when I generally have to litigate or resolve these issues, I find that the staffing company or the company leasing or lending the employee generally has a contractual relationship with the the special employer, the person that they're lending this person to. The parlance in New Jersey is that the general employer is the person who's lending, the special employer is the person who is receiving what they're going to call a special employee, who's not really their employee, but is going to be doing their work on a lent or contractual basis with the general employer. In general, both of them are going to be exposed for the same workers' compensation exposure. Entertainingly, though, usually there's contractual indemnification in there, which will resolve that issue. I just had a interesting issue that arose in our practice, actually in New York, with a general employer lending a special employee to the special employer. He then got in a fight with an employee of the special employee, and we discovered that the workers' compensation exclusivity bar travels all the way up to the general employer, so that's very useful for that client. All right, when it comes to who's my employer, and there could be two alleged employers or even more, really what it's going to come down to is who directs and controls this employee all day. In the context of contractors and subcontractors, where a subcontractor is the actual employer but does not have workers' compensation coverage, workers' compensation exposure and liability is going to be deemed to travel up the ladder towards the general contractor. So that's something to be mindful of. All right, independent contractors. This is going to be a lot of fun for those of us who think, hey, I'm getting paid on a 1099. That means I'm an independent contractor. Well, actually, the workers' compensation courts do not care how the employees are being paid or how we're classifying them for tax purposes. It's going to be really going to come down to a multifaceted test. Who directs and controls the employee? Who has the right to hire and fire them? Is the business of the alleged employee and the alleged employer really the same business? Or is this sort of an outside business who's providing vendor or services to the general employer? Is there a different entity, meaning do they even have any kind of incorporation or legal formation so they can be recognized as something other than an individual? How about who controls the method of the work? Does this alleged independent contractor bring their own tools? Do they bring their own materials? Who's supplying those materials? Do they have their own workers' compensation insurance? So all of those questions are going to be the questions that the workers' compensation courts are going to look to in determining whether someone's actually an independent contractor or just your general employee. All right. I blasted through that because I'm hoping we're getting a lot of great questions and answers on today's topic. And remember, you don't have to confine your questions to just really the quick overview of employment law that I talked about today. It really could be any topic in workers' compensation. So I'm happy to answer any question on anything you bring up. And again, I do find that this to be the most fun part of our presentation generally. Last week, I was doing a presentation on New York workers' compensation law, and someone asked me a question. I just didn't know the answer to it, and I was sitting there pondering it, and someone else typed in the answer in the questions. I was able to share that information with everyone. So, okay, all right, great questions starting off. So, Jim asked me, Greg, can you please speak to the Hager decision last week and tell us how and when we can defend against the use of medical marijuana in the future? So, the Hager decision, I think we kind of briefly touched on this. Yes, medicinal marijuana is going to be allowed for palliative pain care where everything else has failed, and we now have precedent for it. Hager, by the way, worked for a contracting company. He was a laborer for a contracting company. He was injured. Just to put this in a little context for you, his disability was adjudged to be 65% of partial total, so that's a pretty significant or pretty high disability. He complained that the opiates and the medications he was on were not helping him. In fact, were making him worse, were making him unable to carry out his activities of daily living. And he went and pursued the medicinal marijuana on his own, and claims that it was helping him and helping him in different ways, and then sought reimbursement by way of motion for med and tab. Now, that case has a tortured history, and you can't really tell the tortured history of that case by reading the Supreme Court sort of synopsis of it, because Hager went through multiple attorneys. He's really doesn't have much of an employment background. As we all know, treatment for pain is relatively subjective. So the real takeaway was that there has been this long challenge going on to medicinal marijuana coming into workers' compensation cases, and really based on, hey, look, there's all sorts of federal issues here with paying for it. Most other states they're still grappling with this. New Jersey is one of the few states that has a compassionate use statute. New York has one as well. And the way in which the courts sort of have routed around the typical way that medical treatment would be resolved, that would be, hey, you're the carrier, you have the liability or the responsibility for paying for this treatment that's been provided. Normally you would just pay the provider, but you can't do that in the context of medicinal marijuana. And so the way the courts have routed around this is to have the claimant be directly reimbursed themselves. The petitioner is getting this check to reimburse. So that's the way they've routed around that. And it looks like that's going to be the law of the case. Again, there is going to be an appeal pending on this. I've heard that the appeal is going to be up to the federal courts. However, pending the federal appeal, we don't expect any kind of stay. So we'd expect that this would be the valid case law that we're going to be defending under. Can these cases be defended? Yes. And how would I defend them? Well, I'll be looking at the severity of the injury, what kind of subjective complaints there are. I mean, in that case, Hager, it's all subjective complaints. It's just, I have pain, I have pain, I have pain. Knowing what I know about the background of the context of the case, no, I think I would have defended that case quite strenuously, just as it was defended quite strenuously, based on this claimant's work history and his psychosocial issues, etc. But in this case, both the trial courts and the appellate division and now the Supreme Court have all said, now this is going to be a valid palliative treatment. All right. Michelle asked the question, Greg, have you ever seen any changes in the opening of the courts? Any idea when they will be opening for claimant testimony? Yeah, no, nothing. So they just keep pushing back. Now, New Jersey, the superior courts have announced that as of May 23rd or something, right before Memorial Day, they are going to allow some in-person proceedings to take place. But remember, the workers' compensation courts, they're not really courts at all. Right? A workers' compensation judge isn't a constitutional judge. They can't marry you, they can't divorce you, they can't throw you in jail, and they can't sanction you. They can't do any of those sort of constitutional things that a superior court judge can do in New Jersey. They are a creature of the administrative body that creates them, which is the Department of Labor. And the Department of Labor has not given us any information about when they're going to reopen or how they're going to reopen. Certainly, it's been, 13 months now since they've been closed. In the beginning, the chief judge was issuing out memos like every couple of weeks saying, oh, we're going to open in 3 weeks. And then 3 weeks ago, I said, okay, 3 more weeks. And then that just ended. I think in July, they said, okay, until further notice, we're closed. And now there doesn't seem to be any really clear plan for how this is going to be reopening. All the courts in New Jersey are operating under their own sort of different little guidelines. Some of the judges have published, okay, here's how I'm going to call the list. Here's how I'm not going to call the list. I'm going to do this over the phone. I'm going to do this over video. I'm doing this via email. So we're seeing a lot of variation between how this is working among the different courthouses. All right. Michelle asked the question, Greg, if the driver has an OCAC policy, can they still file a workers' compensation claim for permanency? Yeah, no, right? We've seen it, of course. I've seen employers who are attempting to classify their employees as independent contractors require that those alleged independent contractors get their own occupational accident policy. And in general, by the way, when we're defending a case and we're saying, look, judge, this over-the-road trucker, judge, this delivery person, judge, this driver, it's typically in the driver context, they're really not an employee, they're really an independent contractor. And I'll prove it to you, judge. Look, they have their own occupational accident policy, which, by the way, judge, is going to pay them the same benefits they would have been entitled to under workers' compensation. So, judge, does the court really have any interest in pursuing this? I think that's a great argument to make in court, and generally it's very persuasive. But whether or not they have an accident policy itself is not going to be really a very dispositive thing. We really are going to look at who controls and directs them, how dependent were they on that single source of income, are the businesses truly separate, all of those types of things. Can they set their own hours? And particularly in these gig economy cases, it's been very consistent since the first challenges started emerging in 2016 and 2017. Gig economy employees or people, DoorDashers, Uber, Lyft, they have been consistently held by the workers' compensation courts to be independent contractors. And really chiefly, they've been pointing to the fact that they can choose when they work, they can refuse to work, they can come when they want to work, they can turn the app on, they can turn the app off. And that's really been the chief reason that they've been found to be independent contractors and not eligible for workers' compensation benefits. So Michelle asked the second part of her question, which is, hey, can they still file a workers' comp claim? Yeah, they can still file the claim, but we'll dispute it and defend it on the basis that they are not an employee. And generally you should win. All right. All right, Jim says, hey, Greg, you mentioned we can challenge medicinal marijuana. And he points out to some regulations say the physicians must also hold a bona fide relationship with the patient in order to register them with the program. So let me just stop there for a second and talk about registration in the program and the program itself. A couple years ago, I want to say about 2 years ago, my partner Tashi and I, we did a lengthy presentation about the Compassionate Use Act in New Jersey. And we just kind of laughed about what a joke the whole thing really was. In order for a physician to be registered, they really just are going on and they're filling out an online questionnaire. I think they have to take a online course that's like an hour to get their certification. It really wasn't like very strenuous at all. I mean, they are limiting who can prescribe it. So, they're not letting like chiropractors, write prescriptions or acupuncturists for medicinal marijuana. But other than that, other MDs or DOs who take these online course and fill out the form, they're going to be able to write these prescriptions. So it's not that rigorous. And then Jim says, but they're supposed to have this bona fide relationship with the patient. Sure. I don't know who's checking. I mean, in the case of Hager's, the reported decision, I can tell you that, he was seeking the care on his own. He did argue that it wasn't curative. He admitted it wasn't curative, but he said, this is very palliative. I'm getting much better activity of daily living, much better function. And so for that reason, the courts look to that. Will we be successful, Greg, in raising this issue if the injured worker just goes out and finds a provider for medicinal marijuana? So that's a great point. I mean, we're going to look and go, Judge, how do we know this works? Are they just doctor shopping? I mean, they're just looking up and down the block to see who says I have the license to treat you this way. Are we going to see this big diversion that we're expecting to see? That's, I think, the issues that we're going to have to bring to the court's attention. Greg, do we only argue, this is Jim Stowe's continuing question, I'm a little concerned, I don't really understand the last part of it. You say, and we argue we only pay for prior medicinal marijuana after 1 year of treatment. I guess what you're saying is they have to prove that it's been successful for them or it's been working. Yeah, that's the challenge. They've got to show, hey, there was some benefit to it. And it can be retrospective, right? So we are going to look backwards and say, look, it got them off the opiates. You know, maybe now they're off all of these other medications. With the opiates come all sorts of other complications, as we know. Certainly, even things as basic as constipation. Now they're on a second medication to treat the constipation, et cetera. Long-term opiate use has all sorts of deleterious effects over time. So we would be hoping that some of those comorbidities or other issues or medications would come down. So that's, I think, how they would be able to demonstrate that it's been valuable. All right, Sarah P. asked the question, Greg, what is the test in New Jersey to prove a person is an independent contractor? All right, great question. We did talk about that in the slides, but really the question is, who has the right to direct and control this employee? Who has the right to hire and fire them? Are the businesses truly the same or are they different? Does the employee have their own entity that they can hold out as a separate entity that they are actually working for or owning? Okay. Whose license are they operating under? Who brings the tools to the work site? Who brings the materials to the work site? What is the financial relationship between the parties, where the independent contractor has only one client and works for them exclusively and is completely dependent on them? The courts have consistently said, you're not an independent contractor, you're actually an employee. And certainly, do they have their own workers' compensation insurance? So those are all the main factors that the New Jersey courts are going to look to determine if someone's been an independent contractor. All right, great questions. It always, that's the last one I see popping in here at 12:24 p.m. So if you've typed another one in and I get it after this ends, I will email you the answer. Thanks for joining us today. This was a lot of fun. And anytime we can talk about medicinal marijuana, I'm happy to. And next time we'll do this live and we can all do some free samples. We'll try it out. Our next webinar series, I'm glad I made you laugh with that one. Okay, our next webinar series is May 28th. And we're going to talk about defenses to the basic defenses that we raise, both jurisdictional and substantive, to a workers' compensation case in New Jersey. Thanks for joining me today, everybody. Hope you have a great week. See you soon.